Hello, everyone. Thank you for joining us for the last call of the year 2021. I'm very happy to have a conversation that's going to be broader than not just because I think online forms are the bomb, but broader than just forms and technology, and really look at the space where we're working on access to justice technology from a more holistic and broader point of view, including policy, reform, and other aspects of building a better, simpler, less complex system for those that have been orphaned by the system and by the legal profession. So we have an amazing group of panelists, and without more, just some quick announcements. We're gonna record this. I'm going to post it in the resource page, and we'll also put the video available in a page without sign up. So anybody who wants to listen to this can. And so this will be available if you want to review later on or share with other contacts interested in this type of work. And the agenda is very simple. We're going to start with Marc Lauritsen, who's going to give us some context. Marc has been, many of you know him, and he's been working with us on LHI, both in technical capacity, but also as an advisor to Pro Bono Net on Law Help Interactive. Then we're going to be followed by Jim Sandman, who is now teaching at the University of Pennsylvania Law School, a class on leadership and a class on simplification, and he is the former president of the LSC Corporation. Then we're gonna switch and look at a local project, and Jim is gonna talk to us about simplification. Then Amy Billmeyer is gonna give us an example of the work that's happening in Michigan State to come to uniform forms, which is a related topic to simplification. And we'll talk about how they're working with the courts to achieve that with the online forms. And then we're very lucky we have Lynn Greiner, who is in Washington State and is now retired, and she's joining us to talk to us about the Plain Language Project in Washington State, which was a seminal project and probably one of the main projects where forms were put in plain language. All the family law forms, I think it was over 200, were put in plain language, and then that is what led to the amazing project that Laurie Garber from Northwest Justice Project has been working on with the Office of Civil Legal Aid and NJP, Northwest Justice Project, in automating the forms in family law. And I'm going to be moderating and checking the chat. We're gonna look at the questions and chat at the end of each person's section. And I'm hoping that we're going to have at the end 20 minutes or so to have people, all of you, thank you for joining us, comment or share or ask questions, take this conversation to a higher level from an analytical and also collaboration, partnership, and modeling point of view. So that's kind of the plan. So thank you all. I am going to switch now to Marc.
Hey, good afternoon. Hello, everybody. Just a few preliminary observations to get us started. I think we all know that there are many sources and forms of complexity when it comes to people having to do legal work and deal with legal situations. Some of those complexities are inescapable because of our adversarial system and the complexity of the underlying law. But a lot of that complexity can be managed, can be reduced on behalf of folks who are not comfortable working in that environment, which is most of our clients and other fellow citizens. So as sort of a second basic observation is simplicity is not really simple to achieve, right? There are many ways to attack it. We're going to hear about plain language strategies, which are clearly a form of addressing complexity. How do you make the actual texts of the forms, of the instructions, of the interactive applications on places like Law Help Interactive? How do you make those accessible to people? Secondarily, what about folks who don't have English as a first language, let alone legal English? So how do we support more than one language, ideally switching between them on behalf of users? Then, of course, there's the strategy of streamlining the underlying processes, getting the courts and the legislatures in the game to make the work itself easier. which could involve legislative and regulatory fixes. And then another strategy, which I think a lot of us in this community have invested quite a bit in, is how do we use machines to delegate to machines some of the work involved in understanding what actions need to be taken and what decisions need to be made in various stages of litigation and other kinds of controversies. So these are all possibilities. I think, uniformity and standardization, as important as they are, don't directly address simplicity. I mean, if I am working in county number 1, I don't really care whether county number 2 is as simple or as complex as where I am. I just care about the county I'm in. It could be simpler for developers and program managers if there is standardization and uniformity. And secondly, of course, we have to acknowledge that automating things does not necessarily advance simplification. You can make things more complex and more obscure through technology. And a final consideration, which we may hear as we talk further today, is who's being simplified? Whose work is being simplified? Are we simplifying the court's work? Are we simplifying the program manager's work? I think we all mostly agree that the goal is to simplify the end litigant, the end user, the person or persons who are trying to get their legal work done. And how do we make that simple? So I really wanted to be short. Claudia, I think you might have had some general observations in your slides next, but if not, please proceed with the schedule here.
Thank you, Mark. Excellent introduction. Yes, I think from my perspective, when I think about the unrepresented person, the person that I call the orphan, from their perspective, they're looking at chaos, right? To them, it's a very chaotic system. Before litigation starts, while they're in litigation, if it ever gets to that case, because not all cases actually end up in court. And then after the litigation, what happens? How does that affect their life or the life of those that they are responsible for, right? So from this person, it's chaos. And we as trained, litigators, lawyers, people who study structures of governance and stuff, we understand, some of the reasons and what's pushing and creating all of this chaos from this person's point of view. But understanding the reasons, and this is not complete, but understanding the reasons doesn't really help us. And so this whole call is for us as a community, all of us who are here, is to really focus on the last point that Mark said. How do we eliminate the unnecessary complexity for the litigant, not for the system, not for the profession, not for those that are in decision-making authorities, but for the litigant. And then to really start being very clear as we go after this, to talk and to really be able to express the benefits of simplification. And, as somebody that manages the largest platform of forms in the US, yes, that is very, very good for technology and for forms, in particular form platforms. So it could be very self-serving. But I think that aside from the benefits of simplifying and collaborating and getting to standards and productization, there's also the benefit to the public, to the person that's orphan. So how do we speak about that? How do we convey that? Because I think that we need to really rethink this. And so I am going to transition us to really great hands, and I'm going to let Jim take over and share his approach and work on simplification.
Thank you, Claudia. I'd like to talk about the need for simplification broadly, not just simplification of forms, but simplification of court processes. The National Center for State Courts estimates that in 76% of civil cases in state courts, at least one party doesn't have a lawyer. What that means is that the model our system was based on, where you have lawyers representing both parties, presenting facts and arguing the law, is a fiction in the overwhelming majority of cases in civil state courts today. It wasn't always this way. In fact, this phenomenon of huge numbers of self-represented litigants is of relatively recent origin. The earliest study I can find about the phenomenon dates from 1976. It was a comment in the Yale Law Journal written by a Yale law student who was unidentified at the time. She did a study of 2,500 divorce cases in 2 trial courts in Connecticut, and she reported that in 2.7% of those cases, at least one of the parties did not have a lawyer. Noted a roughly contemporaneous study that had been done in San Mateo County, California, which found that in 20% of divorce cases in that county, at least one party was unrepresented. She characterized that figure, 20%, as an unprecedented surge in self-represented litigants. There were subsequent studies done over the 1980s and the 1990s, typically focusing only on domestic relations cases, which tracked a significant increase in self-represented litigants over that time until by the mid to late 1990s, you saw figures of the magnitude that we have today. Of course, this phenomenon is not limited to domestic relations cases. It affects most notably eviction cases, where typically 90% of tenants don't have lawyers, debt collection cases, where typically more than 90% of debtors don't have lawyers. I've tried to find research on the explanations for this increase. I've come across none. My guess is that the explanation for the increase depends on the type of case. For example, in debt collection cases, I suspect the increase in numbers is related to consolidation and commoditization in the debt collection industry that turned debt collection into a machine that it wasn't in the mid-1970s. In his book, Evicted, Matthew Desmond notes that there are a lot of reasons for the increase in evictions. We didn't used to have the eviction rate that we have today. One of the most important drivers of the increase is changes in federal housing policy, where we're spending less on affordable housing than we did previously. Whatever the reasons, we now live in a world very different from the world for which our rules were created. Our legal system was created by lawyers for lawyers on the assumption that everybody's got a lawyer. And it doesn't work for self-represented litigants. We're forcing self-represented litigants to play by rules developed for a world that ceased to exist sometime in the last quarter of the last century. The system hasn't adapted to the reality that the typical litigant today in civil cases in state courts is self-represented. One observer put it this way. He said, we need to make law less complex and more workable. He said, lawyers have been paid and paid well to proliferate subtleties and complexities. It's about time we brought our intellectual resources to bear on eliminating some of those intricacies. The speaker was Attorney General Robert Kennedy in 1964, before we actually had this huge increase in self-represented litigants. He was speaking on Law Day, May 1st, 1964, at the University of Chicago Law School, roughly a year after the Supreme Court's decision in Gideon versus Wainwright, and he was commenting on the need for change in the civil justice system. In the years since he said that, I think the situation has only gotten much worse. We need to simplify court processes. And I think we need to do it by starting over again, by redesigning the system that we have. Mere tweaks are not going to do it. I think we need to bring principles of user-centered design, which were developed in connection with consumer products and services, most notably in connection with technology, to put the real-life user at the center of the design process from the beginning and recreate the system that we have. Lawyers are not good at this. If you put lawyers in charge of simplifying court processes, they're likely to start with translating the Latin into English. Well, that's a start, but it's not nearly enough. Lawyers, by training, are inclined to start with the status quo and tweak it as opposed to starting all over again. So if we're going to engage in this process of simplification of court processes, I think we need to bring other people to the table, people who have skills and training that lawyers do not. And if we tend to think in our insular, elitist lawyer mode that no one else can do this because law is different, I don't agree. I think there are fundamental concepts about design, about how to design complex products and services for individual users that have been honed in other contexts that are transferable to a redesign of the legal system. Now, I hear some people say that some of the complexity built into the law is there for a reason. It's there to provide protection to people. And if we mess with it, if we oversimplify, we may end up inadvertently doing away with protections that were created to help people. I have two responses to that. If people can't use the system at all, the protections are not of much use. If the system is so complicated that the availability of a theoretical right or defense is out of reach to people, what difference does it make? But second, I just don't agree with the premise. At least I don't agree that the complexity is necessary and can't be avoided until we bring people who are trained in user-centered design to the table, present the problem to them, tell them what our lawyerly concerns are, and see if they can't help do both, provide protections for parties and simplify court processes. I think this is absolutely essential if we're going to deal with the reality of the huge numbers of unrepresented litigants in our courts today, and I feel particularly strongly about it because of the nature of the cases in which so many people are self-represented. These are cases that are high stakes, not high stakes because there are billions of dollars at issue, high stakes because there's something more important than billions of dollars at issue. What's at stake is the most basic of human needs: shelter, the roof over your head in eviction and foreclosure cases, personal safety in cases where a victim of abuse needs a protection order against an abuser, family stability, child custody, and child support cases. These are about the most important issues facing a human being. And when they're entrusted to the legal system through a process that people cannot understand and cannot use, that is not right, and we need to bring a sense of urgency to dealing with it. Forms simplification is obviously a component of this, and people who work on simplifying forms, I think, have a very important contribution to make, because they're often likely to be in the position of seeing this underlying complexity that form simplification by itself won't solve. So they can be the lookouts for the problems that we need to get to at their root and direct experts in user-centered design too. They have a critically important role to play in that. And I agree with what Marc said about automation not equaling simplification. You know the saying, if you automate a bad process, you end up with an automated bad process. We need to be very conscious of the limitations of automation in dealing with the underlying complexity. Let me give you another example of system complexity that form simplification can't deal with on its own. At least until relatively recently, I don't know if this is still true, but as of a few years ago, in the state courts of New York, if you wanted an uncontested divorce, you had to file between 12 and 21 different forms, the precise number depending on whether there were children involved and whether one party was seeking support from the other. 12 to 21 forms? I've looked at the titles of those forms. I'm a lawyer, but I'm not a New York lawyer. I can't understand the title of the form. Why in the world do there have to be so many forms? Why can't forms be consolidated? Why can't there be fewer of them? Why do there need to be so many steps in the process? those are the kinds of things I'm referring to when I speak of the need for process simplification. So I just urge that in the work of automation and creating document assembly applications and form simplification, the need for underlying simplification of court processes be focused on. We have to tackle that if we're going to solve this problem.
Thank you so much, Jim. That's definitely a call to arms, and we hear it. I'm gonna transition now to Amy,
Hi,
who's
everyone.
gonna share with us her work in Michigan.
Yes, hi. Can everyone hear me okay?
Yes.
Okay, thank you. I'm just going to introduce myself first. My name is Amy Billmeyer. I'm an attorney at the Michigan Legal Help Program. Michigan Legal Help is part of the Michigan Advocacy Program, which is one of the LSC-funded legal aid organizations in Michigan. MLH is a nonprofit supported by the Michigan Supreme Court, the Michigan State Bar Foundation, and through grants from the State Bar of Michigan, LSC, and others. The Michigan Legal Help website was launched in 2012, and since then we have also helped open up self-help centers across the state and support other pre-existing centers where navigators help self-represented people to access our website, prepare forms, and find instructions and information to help with their legal issues. We also have a live chat feature on our website to help visitors find information. But today I want to talk mostly about forms. Among our other content, we have 52 form tools which generate 184 possible automated forms. And our data for this year, just to give you an idea of the scope, shows that website visitors produce on average 783 sets of forms per day. While all of our form tools are drafted by MLH staff and created by our developer, the tools themselves are hosted on Law Help Interactive. And our second most used form tool is the one that prepares the petition for a personal protection order, which I'll be calling a PPO. Today, I'm going to focus on one particular issue that we are navigating with regard to uniform forms. And that is the challenge posed by local forms that coexist alongside uniform forms approved for statewide use. I'm going to talk about some of the issues with local PPO forms and how we had an opportunity to begin negotiating with courts about their local forms during the pandemic. But I'm also going to talk about some of the lessons that I have learned from local forms that have been steering us toward more discussions and collaboration with the courts and with the state court administrative office to improve the statewide form. And if there's a little bit of time at the end, I would also like to give just a brief summary of process simplification work that our director, Angela Tripp, has been working on with Michigan's Justice for All Commission. So first, I want to give a brief history of Michigan's statewide forms. Our State Court Administrative Office, or SCAO, has been authorized by court rule to create standard court forms for statewide use. And this has been going on for longer than anyone at MLH can remember. The court forms have been around for at least 15 years and likely longer than that. There are several form committees that meet yearly to discuss form revisions and new forms, and the committees are comprised of local court staff from jurisdictions across the state, some judges and some court clerks. There are attorneys from government agencies, members of the private bar, representatives of different state bar sections, and attorneys for Michigan Legal Help. At this point, SCAO has approved almost 1,000 court forms for statewide use. As recently as 2011, even though many of these forms were available for public use, not all courts were accepting them. But in 2011, as a result of the work of the Solutions on Self-Help Task Force, which also gave birth to Michigan Legal Help, the state court administrator issued a memo to the courts that made it clear that our state court rules require all courts to accept SCAO approved forms. The court rule also provides that in order to mandate the additional use of a particular local court form, a court must adopt a local court rule for that purpose. And the state Supreme Court has to approve all local court rules, although in reality we found that not all courts that require local forms have adopted a corresponding local court rule. And in our work at MLH, we've often grumbled to each other about the use of local forms for a few reasons. One drawback of local forms, of course, is that they make it more complicated for us to provide accurate procedural instructions to self-represented litigants. It's our policy at MLH not to automate local forms, but we do provide step-by-step procedural instructions for each set of forms. In some areas like divorce, we have developed county-specific procedural instructions for many of the counties, especially for the larger ones, because procedure varies so widely from court to court. In the county-specific instructions, we provide links to required local forms. Of course, local forms are only one piece of the difference in procedure among courts, but still the time that it takes to create and update county-specific instructions could be better spent on developing new form tools and improving existing ones. Another downside of local forms is that they can be unnecessarily time-consuming for litigants as well. In my own areas of content development, the process where we seem to have the most local forms is with the petition for a PPO. There is a uniform petition for a PPO that existed long before MLH began, and it has gone through several different iterations that I'm aware of. All 83 counties have to accept it for filing, and yet many counties require anywhere from 1 to 5 additional local forms to be filed along with the statewide petition. Beginning last year, I started to take a closer look at some of the local forms, and many of them ask for the same information collected by the statewide petition form. So the duplicative parts of the forms are a waste of time for self-represented litigants. And where the local form requires them to again describe the incidents of abuse or harassment that they experienced, which they already typed up in their petition, that can be re-traumatizing for petitioners. Another problem is that some of the local forms ask for information that is either irrelevant or sometimes even directly undermines the law. For example, Michigan law provides that a court cannot refuse to issue a PPO simply because there is no police report or because there is no medical report. And yet, many of the local forms ask questions such as, if there is no police report, why isn't there one? Or, if you did not seek medical attention after the incident, why didn't you? I believe those types of questions are undermining the PPO statute and inappropriately trying to probe into the petitioner's motivations instead of focusing on the behavior of the respondent. A fourth problem posed by local forms is that they are unlikely to work with e-filing. There are many states that are way ahead of Michigan on e-filing, but as of now, there are only 8 courts in Michigan using the statewide e-filing system, and several of them are using e-filing only for a very limited number of case types. So we have a long way to go, but one thing that will happen is that eventually Law Help Interactive and the e-filing system will be integrated, and we don't think it will be possible for users to upload separate local forms along with their petition once that happens. So with those problems noted, that's not to say that the local forms are entirely evil. What I began to see last year, and I'll talk more about this in a moment, is that the existence of all of these local forms suggests that the statewide petition may be insufficient in some ways, and that there could be value, and I believe there is value in analyzing what these local forms are trying to do. The pandemic was the event that forced the issue of what to do with local PPO forms for us. Without e-filing, most courts in Michigan were scrambling to figure out how to accept filings when the courts were closed, and even the ones that were set up to accept some e-filings were not accepting e-filing for all cases. Most of them began to accept filings by email, which came with its own challenges. Then LHI developed an email to court feature that allowed litigants to email their completed forms directly to courts from the LHI website. And this feature unexpectedly allowed us to begin dialogue with the courts about their local forms. Without even having to pitch the idea to them, our largest county in the state, Wayne County, approached us with the goal of having all their PPO petitions filed electronically through LHI. The problem we encountered was that they required 4 local PPO forms in addition to the statewide petition. But they agreed to let us walk them through our form tool and show them where we already covered a lot of the information asked in their local forms through the screening questions in the interview. And where we didn't cover certain information, we got to have the conversation of why their forms asked for certain information and what purpose the information served in the judicial determination. After a few weeks, we came to the agreement that they would drop all their local forms in exchange for our adding 2 questions to the interview and placing the responses in the existing addendum form. It ended up being a fairly quick negotiation process and easier than I expected, in large part because of their motivation and desire for the email filing capability. When we started discussing their forms, my anti-local form bias was pretty strong, but I did see that certain information they wanted from petitioners, even though it might not have been required by statute, was something important for judges to know when they're deciding what specific protections should be in place. For example, if the parties live in the same apartment complex, it can be useful for judges to know how close the apartments are so they can qualify the prohibition on the respondent appearing in the petitioner's site. Otherwise, there could be daily unintentional PPO violations if the parties live on the same floor in their apartment building. After the email to court function was successfully set up for Wayne County, we reached out to the state court administrative office and asked them if they could include information about it in their newsletter to the courts to let them know that this was an option for them if they had issues with email filing. We had about 10 other courts without local forms sign on to enable the direct email filing option on LHI. And around that time, as local forms were on my mind, I also reached out to the state court administrative office to see if they could help us organize meetings with the courts to address whether the uniform PPO petition is sufficient, and if it isn't, to make the necessary changes so that all courts with local forms have a say in the process, and so they feel comfortable getting rid of their local forms. SEAO liked this idea, and if all goes to plan, we will have a series of meetings next year that also involve legal aid practitioners and domestic violence advocates. So we have a wide range of expertise and voices to protect the interests of petitioners as well. In the, in the meantime, the Oakland County Circuit Court contacted us and asked if they could do the same. And like Wayne County, they require several additional local forms, so I've been having similar discussions with them as I had with Wayne County. But one of their local forms in particular has given me a lot of ideas about how the uniform petition may need to be revised. This local form gathers more information about existing domestic relations cases between the parties when there are minor children, and it gives the court information it needs to order more nuanced protections for the minor children of the parties. This is something that I don't think most courts are doing, but it is allowed by the court rules, and Oakland County is, I believe, really trying to help litigants with this local form. Until we can look at adding those questions to the statewide petition, we are adding them to our form tool and populating the answers in the form addendum. So this is a scenario where a local form is helping us change our form tool for the better so that litigants can provide information to help judges make a better order that responds to the petitioner's particular needs. We wouldn't want to just trash that local form because the result might deprive some parties of important protections for their children. So thanks to the LHI email to court button and the need to expand electronic filing in Michigan, we've been able to start chipping away at the challenges posed by local forms. And the process of speaking with court staff and analyzing their local forms has helped me to see that local forms aren't always problematic. Some of them are trying to gather important information that the current statewide form lacks, and we can use those examples in our future statewide meetings. I think the most important part of this entire experience for me has been opening up more productive dialogue between us, the courts, and the State Court Administrative Office, and that dialogue needs to continue in order to reevaluate and improve existing forms. On a related note, our state's Justice for All Commission has designated funds in 2022 that will be put towards improving all forms. And the project will begin by looking at existing court forms and improving plain language, as well as improving the process of creating and updating forms. So we're really excited for that to happen. And this is completely unrelated to the forms, but I just wanted to give a quick update on what we've been doing regarding simplification and process improvement. Our director at MLH, Angela Tripp, has been working with the Justice for All Commission. There are two working groups, two separate ones, looking at process improvement in eviction and in debt collection. And those two groups are working closely with Pew and the National Center for State Courts to look at how other states are changing these processes. They are those two work groups are doing a detailed process mapping exercise with the aim of taking a holistic approach to process improvement. And in the eviction process work group, they're looking at proposing changes to court rules, court forms, practices, and possibly legislation. Specifically in eviction, they're looking at when DHHS makes rental assistance available. So currently DHHS makes you wait until you're in the middle of a lawsuit. So the work group is looking at proposals to make that assistance available earlier to avoid eviction in the first place. And in the debt collection group, they're working on projects that are more low-hanging fruit. First, they are reworking the summons form and looking at how changes in service might help. So debt collection is working on these smaller tasks, and the eviction group is working on more large-scale change. That's all I have. Thanks.
Okay, thank you. So that's a very nice transition. Thank you for sharing what Michigan is doing, and also the update on the National Center for State Courts and Pew work with courts on process simplification. For me, what I hear from what comes across to me is that if there's not one group charged with really pushing process simplification, the system itself will not do it, because if the system wanted to do it, it would have happened a long time ago. So thank you to all your work and all your efforts in setting up the conversations and setting up the partnerships and the collaborations and the direct feedback and dialogue to get to uniform forms, but also hopefully eventually to a simpler process in those areas of extreme importance to people. So we're gonna transition now, and we're gonna move to Washington State. Very excited to have both superstars, Laurie Garber and Lynn Greiner. I will let you introduce yourselves and hand it over, but let me know when to scroll on the slides.
Okay, thanks, Claudia. My name is Laurie Garber, and I will go first and introduce Lynn and then come back. I am an attorney at the Northwest Justice Project, have been for many years. Northwest Justice Project is the statewide LSC-funded legal aid program in Washington State, and we also operate Washington Law Help, the legal information website, and Washington Law Help now proudly hosts Washington Forms Online, which are our automated forms that we run on the Law Help Interactive platform primarily. And we, with the automated forms that we have on Washington Forms Online, on the Washington Law Help website, we we aspire to Michigan's breadth and depth of collection. We're not there yet, but we're working on it. And we currently have 8 interviews that are live and generate around 45 forms and many more in the works. And we're at about just over 1,000 unique users completing and getting their forms packages every month. And that represents many more forms actually being assembled, because each interview assembles a group of forms for the task at hand. So I want to talk a little bit and ask Lynn to help me talk about it, how we got here, because this really did start with an attempt to simplify the family law process for unrepresented litigants, as Jim was saying at the very beginning, recognizing that that so many people going through these very important court processes are doing so without a lawyer, and that is not how the system intended it. So can you go to the next slide, Claudia? So I've asked Lynn Greiner, who was there at the beginning of this effort, to talk about how we got here, because as Claudia said, the court didn't do this voluntarily. It took a lot of pushing and political organizing. So Lynn, I'll let you take it away.
Thank you, Laurie. Yes, happy to be with you. So I'll just introduce myself briefly. I'm a lawyer, and I worked as a consultant for our state Access to Justice Board starting in 2005. And so that's how I got involved in this. So I'm going to talk to you for just a couple minutes about the form's origin story. It was really a multifaceted 3-year organizing effort where we got to the point where we were really starting to churn the forms out. So I'm going to kind of briefly talk about the steps we took, and with hoping that if you and your state want to do this, you can make it shorter than 3 years. You can benefit from our experience. So in 2009, we at the Access to Justice Board, we'd been talking about self-represented litigants and just how we were just failing in terms of helping them with legal problems. So we decided to convene a meeting, and in the fall of 29 did that with over 25 people, and it was a day-long, really kind of conference or more learning session where we talked about the pro se system in our state, and we had representatives from the courts, we had facilitators, clerks, we had the director of the Office of Administrative Hearings, we had people from our state bar, of course, Access to Justice representatives, folks from legal services offices, really a broad base of people. And we were very targeted in who we invited. We had judges. We reached out to people that were in key positions that we thought would be interested in coming together and helping think about this and how to fix it. So we had that planning meeting. The first thing we decided to do was an assessment of what we offered for pro se litigants in the state, what we didn't offer, where the gaps were, and we also looked at other states to see what was going on elsewhere and what could we aspire to. By the end of 2009, we had the assessment in hand. So then we got busy with committees, key people from that planning committee, and over the next 6 months, we developed our state plan for integrated pro se services, which was just a compendium of here's what we need to do in our state to make things better. And it listed just a lot of tech-based services, which 10 years ago was kind of innovative, but at the top of the list was family law forms, because we knew, as you all have been talking about, just how many people navigate that system on their own. So we landed on converting plain language forms. So that was the planning phase. In 2011, then we entered the next phase where we looked for money and help to implement this plain language form effort. We started converting some of the forms ourselves. I think we did 6, really laborious. We weren't trained. We know it was time consuming. So we immediately decided we needed to hire a professional help. So we turned to Transcend, which is a plain language forms training outfit in California, brought Maria Mindlin up to our area, Seattle area. She did training for a lot of people that were still in the project. And then we decided we needed her to translate some of the forms within her agency. So they did 18 forms, which was a pilot project. And that ended up being key because we took all those forms and then we could really shop them around to the broader community. In preparing for this, I looked back, and in December of 2011, kind of while we were shopping this around, the board chair of the Access to Justice Board, who's partnering with me on this, she wrote to the head of our state bar and asked for $75,000, which would fund conversion of all the rest of the almost 200 forms within 6 months. Ha, ha, ha. Well, we got the money. We didn't finish the forms within 6 months. But in 2012, things really started to gel. Well, I should say in 2011, we also, besides Transcend, started forming work groups to really get serious about how can we convert these forms ourselves, because we realized we wouldn't be able to get the money to hire someone. In 2012, things really gelled. The state Supreme Court Chief Justice Madsen wrote a letter to, quote, Access to Justice friends, close quote, really imploring people in the broader community to get involved with this effort. And that's what happened. Lots of people in key positions came forward and wanted to join and help convert these forms. And then the kind of the crowning achievement, which is really the thing that cemented it moving forward, was in October 2012, memorandum of understanding that was signed by the Chief Justice Madsen, the head of the Access to Justice Board, and the woman judge who was the head of the plain language forms, which is the court entity in our state that does push out pattern forms. And Laurie could talk about this. And Laurie got involved in 2012 while we were just kind of on the verge of that, and her involvement was key. So lessons learned, I think you could make it quicker. It was really, as I said, an organizing effort. We just needed key people and key places, and of course they that were on board, and then they would reach out to other key people. And we had a little bit of money and a lot of nerve. So I'll turn it over to Laurie.
Thanks, Lynn. Yeah, I think that the message that we really wanted to convey was just how much organizing it really took to make this happen, and to get the right people at the table and excited about the project and educated enough about plain language and what that can do and what a difference that can make. The day-long training that we had with Transcend in Seattle, where we also invited court staff and administrative office of the court staff and some judges, the judge who was the chair of the Pattern Forms Committee at the time, who had no plain language skills or interest at the time, was there for that training. And it was a light bulb moment for her, and she became a huge champion and helped us get this memorandum of understanding, where the Supreme Court helped agree that we could to delegate the authority for promulgating mandatory forms to the ATJ group that was creating the plain language ones. And it was not without resistance. We had to do a roadshow around the state to basically calm the lawyers' nerves that, the sky was not going to fall and they would still, have work to do if the forms were easy and simple and clear. But it was, it did just take a lot of communication and organizing and finding a champion. And even then, it wasn't a short process because family law itself is so complex, and there were well over 200 forms to start with, and so we had to whittle those down and get buy-in for all of them. So once we promulgated and finished that form process, which went live in 2016, became mandatory for use by all parties in all counties, we immediately started organizing for the next step, which was to get them automated and make them easier for people to use online. Really use the same tactics of inviting key people to the table, creating an advisory committee to visualize what the project could look like and make a case for funding, which we obtained in 2018. We got $550,000 from the Washington State Legislature for the automation project, and also got a TIG grant from LSC to help support project management for the project, which turned out to be me. And then starting in 2018, we've been building Washington Forms Online. So go ahead and go to the next slide, Claudia. So next slide, Claudia, thank you. So we got our plain language forms, which is great, and now we're automating them, which is also great, but it's really only part of the process, and so I wanted to talk about that next. And I really think of automation as a stress test that you put a form through or a process through, because it really reveals where the holes are, what doesn't make sense, what's not uniform, where it's not clear, what someone should do either before or after, what belongs here, and just reveals all those cracks. And so I encourage anyone who's engaged in an automation process to don't just think about your form, don't just think about how someone fills out the form, but what do they need to know before they get to your form? How do they find it? And what do they need to do with the form after they've filled it out? How do they get through that last mile from their completed form to actually the result and the moving their case forward that they need? So I'm going to focus mostly on the before and after pieces of this, what I've got on this slide. There is a lot of great work being done about the online form automation process itself, of during an automated form experience. Plain language is obviously critical. You want to be minimizing your questions. You're only asking what's absolutely necessary in language that the court user can understand. It should be mobile first. It should be accessible. It should be multilingual. You want people to be able to, if they have to come back and do multiple tasks or multiple interviews, you want them to be able to use their saved answers so they're not re-entering things. All of those are important ways to make the online form completion experience simple during the process. And I want to give a shout out. There's other great projects that have worked on simplifying pieces of that and making things standardized, especially the document assembly line project that the Suffolk Lit Lab has done really great work in this, and also in using all the tools and tricks of technology to make things more user friendly and help fill in your addresses or verify addresses and have online signatures, things like that. So there's lots of ways to make that online part simpler that technology is a really good answer for. But I want to focus more right now on the before and after, which is really about the process of how do you get a court user through the system to the outcome that they're looking for. Next slide, Claudia. So, and I'm going to focus on family law because that's what our project is primarily about. And so we created a map of what is the court user, where are all the steps a court user has to take to potentially get through their case. And this was part of the visualizing our system and figuring out what forms to bundle together and how to make getting through a court process modular, so that people could take bite-sized chunks, step by step. What do I need at this moment to achieve this task in my litigation journey? And then to try to modularize that so that when we're done building it out, and I will say we haven't quite completed all these steps yet, that it can work for any type of family law case. And then how do we guide a user through this process of where they getting from one step to another and making sure they've got all the pieces that they need at any given time. But just this process mapping of how a case works, it can be very useful in designing your system and figuring out what instructions you need to give to a user of how to get through it. So next slide, Claudia. So we focused a lot on standardization of the instructions that we give people, of making sure that people have the information that they need before they start an interview, so that they're successful in getting through it, so they know what to expect. They know what forms they're going to get. They can have questions answered, sort of FAQ format, basic information about this step of their process. And technologically, what are they going to need? What sort of technical needs do they have? Unfortunately, in Washington, we're still at a print it and file it manually phase. I so wish we were integrated with e-filing. That is a future hope. So people need to be warned about that, so that they're not confused and disappointed when they get to the end and find that they have to download or email and print. So we created a standardized template that we do for every interview, where there's always this introduction. You always are going to hear what forms you're going to get. There's always a learn more FAQ to help educate people, and there's always a before you start, so that they're prepped for what they need at this stage. Can you go to the next slide, Claudia? And then once they've gotten through the interview, we've also standardized instructions at the back end, getting them that last mile from their completed forms to the courthouse. So with every forms package that they get at the end, it always starts with the first document is going to be the complete instructions that lists all the forms that are in there that they need to download. And then goes through, talks about where to file and how to serve, and has more complete instructions. And then we created something we call quick instruction sheets that we put at the front of every single document that is downloaded, because as you can see, there are seven files that get downloaded here. I guess it's 6 forms and 1 instructions. And unfortunately, the user has to do slightly different things with each document. So even though they've got their full instruction set that gives the holistic information, we created we felt like people needed to have just a quick instruction 1-pager at the front of each document, so they know, what do I need to do with this document right now, right here, right now. And this is really the equivalent of the sticky notes that I used to put on people's documents when I helped people in person for many years as a legal aid lawyer, helping folks do things themselves. As I always put sticky notes on each document, like, wait, don't serve this yet. You need to, or don't file this yet. You have to serve first. The server fills this out. This one is confidential. You don't serve that one. So the quick instruction sheets are equivalent of those sticky notes that we that lawyers would give people in person. And we took great care to make sure that these were in plain language at the 6th grade reading level when we could hit it, and use a lot of visual cues for people. And these icons you may recognize kind of from Transcend again, and are available to anyone on transcend.net. Next slide. The other piece of this last mile is guiding your users to the next steps. So because there is always more to do, we worked with LHI to create this new next step feature and tile, so that when a user finished their interview for their fee waiver or their filing for divorce, but they still had other things they needed to do, that we could link them directly into the next step that they needed to fill out, and it would carry forward their saved answers, and they would be launched immediately into that next interview that for additional forms of the next step of their litigation that they needed to fill out, without having to start from scratch or scramble around or figure out where they were in that system map that I showed you at the beginning. So this has been a really exciting development that lets us guide people in complex litigation, like a divorce with children, when they've finished their divorce interview, that we can give them the links directly to filling out their parenting plan forms or filling out their child support worksheet and order forms, and then they can start those next steps here. or they can email themselves a reminder to do it later because it's exhausting and it's hard to do this all at once. So this is, these are really our attempts to making a complex system simpler, or to guide a user through a complex system. Ideally, the system would be simpler. I think if we have some time in discussion, I have some goals and ideas for process simplification in Washington that where I hope we can get to a more court-supported case management system that doesn't rely so much on the user to know where they need to go next. But I think I will stop there and let you take over. Okay. And I think you're muted.
Yes, sorry. Thank you, everyone, and thank you to all our panelists. A lot of interweaving trends here. Before we open it up for discussion, just, I wanted just to share that I'm going down into the funnel, but we're gonna come back and have the high view in the conversation. As you're working with forms, one of the powers of technology, whether it be online forms or any other tool or app, is that you have the power to have one tool create many outcomes or outputs. So that is extremely powerful. So when you start thinking about automating a set of support systems for the people that are orphaned by the system, you need to really think about how you're going to maximize and leverage the one-to-many. That also translates to workflows, be it remote or being in person. With the technology, you can also have what our most esteemed colleague, Richard Granat, has been talking about for years, an enterprise model of services, where you have one lawyer and a thousand litigants, with maybe 2 paralegals. These are models that exist and have been proven, and with technology you can do that. But so always thinking about the one-to-many, because it's an opportunity to take advantage of. And then when you start looking at the forms, you really have to take time to plan ahead. When we started the Washington project, we did that for about 3 weeks, and we really made a dent in really standardizing the fields, identifying, because we knew that we were going to be creating these bundles, and eventually the next steps, we wanted to identify what were the fields and everything, the components, the library, the calculations, the language, everything that was going to go from one interview to the other. In a lot of ways, simply saying recycling the fields, but also recycling the answers of the person in need, so that they don't have to spend 20 more minutes again repeating what they had said in the prior interview. And you saw Laurie's very nice logo and icon. That was all very intentional. This one, we also talked about communication plans, branding, how do we create trust, all of these things that come from design. Like Jim said, we lawyers need to get together with other disciplines because we don't have all the answers. So designing, branding, really taking the design of everything to create trust from beginning to end. And a style guide, many other things that we did in this project that I'm happy to share with anybody else working on a large collection. This was the largest collection of automated forms that I have ever had the pleasure to work with in LHI. So really a robust enterprise type model. I think some things that get neglected is that generally end user protocols and supports don't get discussed, they don't get thought about, and those are key feedback moments to keep improving the collection or improving the instructions. So paying attention to user feedback and having a very well organized and accountable backend support that can lead to improvements either to the platform or to the forms. And being very analytical about the feedback, using that to figure out where you're going to invest, either on a form or on a system. And the other part, the technology people are over this. Don't underestimate that. It could be 1 to 4 for every hour developing a form. You may need to have about 4 hours of testing and also have a really robust and diverse group of testers. And Laurie had email list that went to over 100 people, sometimes clerks, courts, lawyers, before she released all the packages so that she could get broad feedback. So standardizing all of this process in your project. And then also standardizing effect. Law Help Interactive is itself a simplification tool because we take care of all the back end and not just the technical, but all the terms and conditions on everything that a user needs to know. So that, and the system, even when we push code, we have protocols, how we communicate to the field. And by being one unified platform, we have simplified form production across the United States. And that makes it a lot easier than if it is state by state or county by county. So really encourage people to think in enterprise systems because these systems are complex and the community is so diverse. And like Jim said, the problems that we are addressing, though maybe dollar-wise, they're limited jurisdiction, personally, they're huge. They're enormous for the person that's dealing with this alone. So think about all of these things as part of the simplification and standardization process. I am going to open it up now to community sharing. And so if people want to raise their hand, I'm happy to unmute you. I know that Laurie gave a shout out to the Suffolk team that was in the call. Don't know if they want to share, or I know that we have other distinguished members from academia in the call. So if you want me to unmute you, raise your hand and I will unmute you. And we did have a question from Laurie Shemka, and I don't know if she's still with us in the call. And I wanted to start by unmuting her so she could ask her question directly. Laurie, there you are. I'm unmuting you now. You're self-muted. Okay, there you go.
Awesome. Thank you so much. And I thank you so much for this presentation to everyone and for giving me the opportunity to ask this question. I don't know if he's still on, but I did want to give a shout out of appreciation to Mr. Sandman for his observation of I'm a lawyer, but I'm not a New York lawyer. I absolutely love that. And I'm not a New York lawyer either. I'm a Michigan lawyer, and one of the first things a trial court judge shared with me when I was admitted to the bar a couple of decades ago was it's something that many of us have heard before, probably more than once. It's important to know what you don't know. And I really appreciate the information that all of you have shared, but I was particularly interested in some of the background of the information that Amy has shared, and I don't hope she feels off if I pose these questions. I am so gratified as someone who lives and works in Michigan for the work that she does. And full disclosure, I don't know Amy, but I'm curious, during the course of all of your local court form fact finding, I'm curious, did the local courts ever volunteer why they had to resort to developing local court forms? In other words, had they previously sought changes to the scale forms, but the state scale rebuffed? Or did the local courts not realize that they could suggest changes to the statewide forms? Or did local court managers simply create the local court forms because their chief judge told them to and they just did it? I'm curious, especially since earlier this year, the Conference of Chief Justices and Conference of State Court Administrators adopted Resolution 3 in support of process simplification. I'm curious of any insights, layers Amy is able to share about this experience, because I kind of think that's in point in this greater journey of process simplification. Thank you so much.
Thank you for that question. I did not get that information from Wayne or Oakland County. I'm on the Domestic Relations Forms Committee, and I know that requests do come in from courts, or they have come in to change the PPO petition and other forms. And there are a lot of requests that get rejected, and often as the SCAO form analysts take a hard line on the form, saying that they only want to include the explicit statutory requirements. And that does make sense as a starting point, but I think what I found with the PPO process is that there is a lot of related information that goes a little bit beyond the statutory language that is very important in a PPO determination, particularly since it's an ex parte determination and the petitioner isn't there to provide additional facts when the judge is making this decision. So I think I'm hoping that with the new funding that's going towards form development, that that can be addressed and changing part of the forms process to look at the statutory requirements, and that should be the most important part, but also to consider, especially with ex parte petitions, what other information judges might need.
You know what, Amy, I think you like sent a shiver up my spine when you gave me the standard scale response. They only want to include the express statutory requirement. And yes, you're right. That's what they do say. And I do think that was also mentioned in the Michigan Justice for All task force inventory. So I share your hope that approach will be revisited as Michigan works forward in its form processes. Thank you so much. I really appreciate it.
You're welcome. Thank you.
Anybody else wanna ask a question to any of the panelists or share about what's happening in their state, or whether they're involved either with other task forces that are working more at the national level on moving forward simplification or uniformity standards and products? I did want to share, I saw this yesterday, some of you may know about it from before, is that the National Center for State Courts has now the opportunity to fund 10 state court systems to do eviction diversion. And so I believe that they said that they have $11.9 million to work with court systems. And I don't know, Amy, if that's the process that Angela is engaged, if she's one of the 10 states that are working on that with NCNC. But I'm going to put the link on the chat. But just calling that out as an opportunity for anyone. I know that we have a multiple state court personnel on the call. If you haven't seen that and that's something of interest, really encourage you to do that, to check it out, and I'll put it in the chat in a little bit. I wanted to bring up the issue of public support. Is anyone working in, because I don't, we know from the Rebecca Sandefur papers that people don't know that they have a legal problem, and that they don't seek legal help, like 47% of people in her Mid-City study. Regardless of whether people know they have a legal problem or not, they're in crisis. They know that they're in crisis. We know that they're in crisis. The courts see them like the emergency room. They arrive at the courthouse in crisis. So putting aside the fact that the public doesn't know that they may have a legal issue, is anybody working on raising community awareness of where this emergency that they're feeling is coming from? Or has anybody thought about that? How do we leverage? Because we get the feedback that people really value the forms, people really value the system, people that that when things are simplified, people provide like very moving feedback to us, and we try to share it. I tweet it, we share it with our partners. So the public wants and needs this, but how do we channel that voice? Because I think that in a lot of these conversations, that's what's missing. We're centering law, we're centering lawyers, we're centering courts, but we're not centering the person that I call the orphan. So how do we center that voice? How do we bring that voice out? And I'm gonna be quiet, and maybe somebody wants to comment or share on that.
I see two hands up, Claudia, Quentin and Caroline.
Okay, let's unmute them. Let me go. Can I unmute Caroline? You're self-muted. And Quentin. Caroline, you're unmuted if you wanna.
All right, let Quentin go first because he's got something different to say. Mine isn't so big.
Oh, okay. Well, thanks, Caroline. First, I just want to say, like, some of the work that I wanted to share is work Caroline's working on too. I just put a couple links in the chat, Claudia, if you or if someone, one of the other moderators, is able to share. So we have.
Yeah, I just posted.
Thanks. So at Suffolk, we've been thinking a lot about some of these same problems. It's really great to hear the way that different states have been approaching this work. I think that one of the keys that we've been focusing on is templatizing the production of guided interviews to save a lot of the effort that goes into maintaining that consistency manually. So that's something I think we're pretty excited to see how that can play out and work. And Pew is funding us to do a couple of things. One, they're funding us to continue to do some of that efforts to build out new guided interviews, but also touching on Jim Sandman's point earlier, to do some exploration and help courts and states understand their forms at a macro level. So being able to look at a whole data set of forms that a jurisdiction might have, see the patterns, see the duplication, see how usable and easy they are to understand. And we're looking for partners in that work. So if there's a state or a jurisdiction that's interested in kind of any part of that process, from the understanding perspective of what your forms are and what they mean and how duplicative and how hard to use they are, we have some ideas about how to approach that, but we're interested in people coming on early to help us shape what that work looks like, going all the way from actually producing new forms in a really standardized and consistent way that we've found has really reduced a lot of the effort that goes into automation. So I'll shut up and interested to hear what Caroline's gonna say too.
I was going to answer, Claudia, your question about raising awareness in the public and this, we know this issue where people have problems and they don't know they have legal solutions. For the longest time, I kept hearing this legal needs thing. I had no idea what people meant when I never understood what this means. People have legal needs and don't know them. So my understanding is a legal need is you have a problem for which there is a legal solution, and people don't realize that there are legal solutions. But the thing I wanted to say is that I was in California. I work in Massachusetts, and I was in California for a good portion of the summer, and what I noticed were these huge billboards all over the place. There were radio advertisements and billboards everywhere, advertising help with rental assistance or being evicted. And I think that, it takes money to do that. But I think what we need to do is we need to go where people are. In California and San Francisco, they're on the roads a lot. But that same thing is we need to advertise in that way. And probably about some of the very specific big issues that people experience. And once people are basically hooked on a big issue, then we know that people don't have one legal issue, and then we can sort of address some of the other issues that people will have inevitably. But I think that's the thing about the whole lawyer legal outlook, is coming from the legal point of view, whereas, okay, what are the big problems people are facing, and address that, and forget about court, court. I mean, the automated forms, they're a tool to deal with the problem, and I think that we need to think more about that. And I was really impressed with the way, I don't know who's doing it in California, but I saw, the billboards and the radio advertisements everywhere. And I think we need to think more about that. And, I don't know how we're going to fund it, but I think that is as important as the work we're doing is getting people connected with the work we're doing.
I really appreciate you sharing that. I wonder if we have folks from California in the call who could share a little bit more, because the going to where people is, that's what a lot of the mobile outreach units have been doing since forever. Like I remember in Santa Clara, they called it the Mamobile, and it was a domestic violence mobile clinic that the self-help center run, and went all over the Spanish-speaking sections of Silicon Valley, the ones that remain that have not been gentrified, did a lot of outreach, and people could file their forms right there and there. And, it was like they could do the online forms and then they could file them right then and there. The going to where people is clear, but also taking more of a public health approach, right? Decentering law and bringing in other disciplines, like Jim said, and you're looking at opinion makers and mapping who is talking to who in the communities and reaching out to them. I see a lot on Instagram happening right now from community groups that are starting to become very cognizant of the lack of legal resources because of their either language or gender identity or disability status, and they're becoming self-organized and starting to kind of really get more savvy. Anyone from California on the call that could talk about communicating directly with people without going the legal way? Because not everybody's going to be in court. A lot of people don't want to even step into the court. I see a couple people from California. I don't want to call on you because then I'll feel like a law professor. Nothing wrong with that. But
This is Laurie again. I'm not from California, but I just wanted to give a shout out to the concept of a communication strategy, and that it maybe shouldn't be done by lawyers. So in Washington, a couple of examples, we have a new right to counsel in eviction proceedings law, which is much needed. But our Office of Civil Legal Aid worked with the legislature to make sure that there was funding for a communications strategy around that, so people would actually know that they had a right to counsel. And so we've been, Northwest Justice Project has contracted with the communications folks to do this work that we are not expert in as lawyers. We're good litigators, but we're not necessarily good at communication strategy. So, building in the funding for especially a new big projects like that is really helpful, and going to those outside experts can make a big difference.
Yeah, thank you, Laurie. It's true that the communication strategy sometimes is best not left in the hand of lawyers. And because then we know we're going to get a bunch of text and a lot of legalese and really not mapping to where the community is at. We have 3 minutes left. Marc Lauritsen or Jim, any of the panelists want to make any closing
Claudia,
remarks?
We had an offer from Jia Min Cheng in question to talk about the California experience.
Okay. Let's just listen.
DRC. Yeah, so.
Can we unmute Jan?
She's on the list. Yep. I'll let you do that.
Yeah, I'm looking for her. Hold on.
JIA.
Yeah. Okay, there she is. Jan, I'm unmuting you.
Okay, great. Hi, everyone. I'm Jimin Cheng. I'm a supervising attorney at Disability Rights California. We are the protection and advocacy system for California. So On staff, we have advocates. So our team is a team of attorneys and advocates, and we work closely together to figure out how to put out outreach material. And one of the plans that we have so far, as far as our housing work, is because our office also includes work with the regional centers, which are scattered throughout California, and they work directly with people with intellectual and developmental disabilities. We want to start doing trainings with their staff, since they're so they are far more integrated into the communities than we are. So doing trainings for the regional center staff, and then through the staff accessing their clients as well. So getting inroads into the community in that way. So the families who are clients of the regional centers in California. So that's one of the plans that we have as far as just getting information out there for people about what their rights are and pointing them in the right direction for where to start finding information.
Thank you. That's very, very good to hear. We are at the top of the half hour. I put an offer on the chat that if anybody wants to send me other resources that I did that would be helpful to move this forward, happy to include them at the slide deck here before I publish it. And I really want to thank everybody that stayed with us for an hour and a half. I hope that this has opened some ideas, and as a community, if this is something that we want to talk about again, touch base, or if anybody wants to work individually or in collaboration with other groups and states, from a technology and an access to justice point of view in the nonprofit sector, please reach out, because I think that this is really important, and we need to bring the world that we want to see now, not tomorrow, not in 20 years, not when all the state bar's done approving things that should have been approved 20 years ago. So in the spirit of new beginnings, and in the spirit of making the world better, reach out and let me know if this was of interest. You will get an evaluation survey after this call. Share your feedback, and if you want to send me anything to include in the back end of the slides, I will. Put C. Johnson at probono.net, and everybody who's taking time off, have a very nice, peaceful time off over the end of the year. Thank you so much.